Welcome back. There are mixed reactions to the report of the Section 89 independent panel looking into the Phala Phala matter. An associate professor of public law at the University of Cape Town, Richard Calland, says the report fails to deliver the necessary impeccable quality and credibility. For more on this, we are joined by Professor Thuli Madonsela, who's a director at the Center for Social Justice at Stellenbosch University. Prof, thank you so much for your time and for joining us this evening. Now, over an hour ago, you tweeted that you have a lot of respect for Justice Sandile Ngcobo, but Section 34 of the Prevention and Combating Corrupt Activities imposes a duty to report corrupt activities and not money at your own place. Kindly elaborate on your interpretation of the Phala Phala report.
Thank you, Kateha, and greetings to all the viewers. Yes, firstly, I must again reiterate that I have the greatest respect for Justice Ngcobo and the rest of the panel. I quote him during many of the lectures that I give at Stellenbosch University, but I am concerned about the law, especially because I teach investigations and also I teach constitutional law. Section 34(1), firstly, the heading is reporting corrupt activities. Then it says any person who holds a position of authority and who knows or ought reasonably to have known or suspected that any other person has committed an offense under Part 1, 2, etc., etc. And then it also talks about the amount of money. It then says must report such knowledge or suspicion to any police official. So two things there. Who must report? Where must they report? Now, we must read Section 34(1) with Section 34(4). It gives us 10 categories of people that must report. In government, it must be the Director General, that is Section 4(1)(a). Section 34(4)(a). It gives you the Director General or head or equivalent officer of a national provincial department, and then C, any public officer in the senior management service of a public body. Then it gives you all kinds of people, but these are all people who are in charge of institutions, such as somebody who's in charge of a bank, tertiary institution, a partner, chief executive officer. All of these people are people in charge of institutions. If you are in doubt, you have to read this section together with the objectives of the Act. So the first objective is to provide for the strengthening of measures to prevent and combat corruption and corrupt activities. Then it says a whole lot of things. Regarding Section 34(1), it says to place a duty on certain persons holding a position of authority to report certain corrupt transactions. So it's very clear that you're talking about transactions in these institutions, in government, in private sector, etc. So it's very clear that this is an act on corruption, it's not an act on theft. And therefore, you have to read this act and interpret it in its entirety. You have to interpret the act in terms of the scheme in its entirety that it provides for combating corruption and related offenses, such as fraud, etc. I do think that, with due respect, Justice Ngcobo, who has an impeccable background, failed us on this one. He applied a law that doesn't apply in this particular case.
So, Prof, removing of a democratically elected president is no small feat, hence the establishment of this independent panel of 3 fit and proper people to kickstart the preliminary investigations. Are you then saying that the entire panel erred in the interpretation of the law?
That's exactly what I'm saying, and with due respect, I have the greatest of respect for all 3 panelists, but human beings do err. That's why we get dissenting judgments and we get review. This is a duty to report corrupt activities. The president is being accused of failing to report the loss of his own money in his own private property.
Correct.
Nobody has accused him of failing to report money that had been obtained corruptly. And he's not any of the officials that are required to report, unless, of course, you look at the subsection that says, that is C, that says any public officer in the senior management service of a public body. But the president is not a person in the senior management of a public body. Because here they were talking about people who are likely to discover financial transactions. Because this is an act about combating corruption and corrupt activities. And therefore, yes, I am sorry to have to say this about these esteemed colleagues. Here, they were wrong. The other thing is about the reporting. It places a duty to report to any police officer. And protectors are officers. When I was public protector, I reported things that were happening to the officers and expected them to take care of them, and they did. Now, but that's a minor issue. Here, I'm not really concerned about the president, dear colleague. I'm just concerned about how do we apply this law. Because if we're saying anybody who loses 100,000 rand and fails to report it, for whatever reason they choose not to report, they're now guilty under the Prevention and Combating of Corrupt Activities Act. And this is not what the Act is asking us to do.
Right, understood. Prof, now Richard Calland penned an article earlier stating that the president should not resign on the basis of a flawed report, just as you have stipulated. And he partly bases this on the sufficient evidence holding a higher test to prima facie evidence. Is it the responsibility of that panel to test for the veracity of the evidence?
Well, firstly, it was not my intention to deal with the president per se, but yes, I do agree with the panel that there isn't much of a difference between sufficient evidence and prima facie evidence. Having made that decision, I am totally shocked then that the decision is based on sufficient information, because having said there's no difference between prima facie evidence and sufficient evidence, then he's saying that the panel should give to Parliament a product that if no further evidence is adduced by the implicated person, they are automatically guilty. Prima facie says on the face of it. In fact, in the criminal courts, if after the court has reached prima facie evidence or prima facie evidence, whichever way we choose to pronounce this Latin word, and you don't rebut that evidence, you're guilty. So I cannot understand how the panel made the right decision about there being no difference between the scheme for the public protector and the scheme for the president. It then makes a recommendation based on a much lower threshold, which is just a collection of information. My view is that evidence is information that has been tested and found to hold on its own, or at least sufficiently authenticated. And I don't think it's just any evidence. It's any information. In other words, from the information that you've been given, you're then supposed to authenticate that information and test it. Only when you've tested all of the information that we're given and found that part of that information that has weight to be regarded as evidence, you pass it through. And then if there's enough of it, then you then tell us that there's sufficient evidence or there's a prima facie case. I would have expected the panel, as we do as the courts and as the public protectors, that the findings should be the exact wording of the mandate of the panel. The panel can't pick and choose how it phrases its finding. Its final words should be exactly the words that are provided in Rule 129G1.
So, Prof, if this report is considered flawed and dangerous, what precedents do you believe is being created should this report be actioned on?
Well, I don't want to get into that because for me here it's just about what do we teach investigators? Because what's going to apply to Parliament must apply to any investigator who's asked to verify certain information and then submit it to the right authorities to take it further. I understand the panel correctly says this is a three-staged approach, but it's pretty much similar in a criminal trial. Stage one is give us the prima facie test. Only when you pass that test, we go to the person answering. But we know in criminal law that if that prima facie stage reaches the conclusion that there is a prima facie evidence, if you say nothing after that, or what you bring does not rebut that, then you're guilty. So we haven't been given a rebuttable case yet. So I don't know how Parliament should proceed, and I don't want to be considered to be directing how Parliament should proceed. I would say if I were Parliament or if I was involved, I would take this matter on review because it's not about the President. It's about the rule of law.
All right. That was Professor Thuli Madonsela, the Director at the Center for Social Justice at the Stellenbosch University, speaking to us on the law around the investigation of the Phala Phala farm gate that is currently the report that has come out. Thank you so much for your time.